Hello.
Hello.
Is that the Morris you were talking about?
Yeah, just ignore him. He'll go away. So, this segment of our series of videos on the Bill of Rights is on the Second Amendment. It might be helpful if you had a copy of the Bill of Rights, like this one that was given to you in class, and it might be helpful to have you this packet of 23 Supreme Court case summaries that you've been provided with. The last two decisions in that packet are about the issue of the Second Amendment.
A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
So we've commented many times on how many passages of the Constitution and the Bill of Rights are not exactly clear in their meaning, and this issue definitely is relevant to the Second Amendment. If you read the Second Amendment closely, there are two main clauses. The first clause says something about the importance of the country being secure and there being a militia. So there's notions of military service and national defense. And then there's the second clause that actually says something about the right of the people to bear arms. Depending on how you read it, you might believe that the right to bear arms is somehow caught up or involved in the issue of national defense and military service, and that therefore now that we have a standing army that's taken over that responsibility, the idea of people serving in a militia is pretty much old-fashioned at this point. So some people would say that if you read it that way, that there is no individual right to own a gun, because it used to be intended that the government would call you into military service and you'd bring your gun. Well, that idea doesn't really exist anymore. So some people would claim that the Second Amendment is basically irrelevant and that there is no such thing as an individual right to own a gun. Other people claim that the first clause or the first half of the Second Amendment is basically irrelevant because the second clause just comes right out and says the right of the people to keep and bear arms shall not be infringed. So some people want to read it as one full sentence, and some people want to read it basically as a kind of a half sentence where the first part of the sentence just doesn't matter anymore. And believe it or not, this issue just has not come up very often in our courts. Probably the most relevant Supreme Court decision on the issue until recently was from 1930. And it's kind of an interesting case, but it doesn't really help us decide whether there is a right to own a gun or not. Excuse me. It was basically about a specific type of gun, and whether an individual back in the 1920s could have that kind of gun. The decision that was reached by the Supreme Court is not very helpful to us because it was worded so vaguely that if you believe that there is an individual right to own a gun, well, there's wording in that decision that would support your argument. If you don't believe there is an individual right to own a gun and that it's somehow connected to military service of some kind, well, there's wording in the decision that kind of could support your argument there too. So until recently, there was no definitive Supreme Court decision. Do I, as an individual, have a fundamental right to own a gun? Then came Heller, D.C. versus Heller. In 2008, the Supreme Court for the first time declared that there is an individual right to own a firearm for the purpose of self-defense. It is independent of any notion of service in the militia. This was about a D.C. law that outright banned people from owning a gun. And that ban, that complete prohibition on owning a gun, was found to be unconstitutional because the Supreme Court said you do have an individual right to own a gun. However, notice two things. First of all, D.C. is not a state. D.C. is a federal entity. It's a federal enclave. So at that moment of that decision, that decision did not apply to the states. And secondly, the law was an outright ban on owning a gun. That was overturned, but that still left open the possibility of other types of restrictions on owning a gun that are still being addressed today. 2 years later, and McDonald versus Chicago is a required case by the College Board. The Supreme Court incorporated the Heller decision and applied it to state and local governments. Chicago had a similar ban on owning guns, and it was found to be unconstitutional. And since you're familiar with incorporation, the McDonald case it didn't really establish anything new other than it incorporated the right to own a gun that had been established by the Heller case and applied it to state and local governments. I'll try to summarize this real quickly. Until recently, there was no definitive interpretation of the Second Amendment, but the Heller case of 2008, the Supreme Court finally said, yes, you do have an individual right to own a gun or bear arms. And the McDonald case is famous because it incorporated or applied it to the states. At that moment, in 2010, any outright ban on owning a gun at the federal, state, or local level became unconstitutional. However, there are still lots and lots of details that we can fight over on this topic, such as, types of guns, how much ammunition they can carry, and what types of ammunition. Issues like, can state or local governments require trigger locks or requiring laws to be disassembled or locked up? Conceal and carry laws, lots of laws like that are various types are in place around the country. Similar to time, place, and manner issues that we've seen with other rights. Stand your ground laws. I don't have time to describe those, but you can look those up. Some states have what are called stand your ground laws. Who can be denied the right to own a gun? For example, most states, I think it's most states, do not permit people who have a felony conviction on their record to own a gun. There was a federal law called the Brady Bill, named after James Brady, who was severely wounded in the assassination attempt on Ronald Reagan in 1981. He survived, but was severely injured and has become sort of a spokesman for the issue of gun control. Anyway, a federal law was passed in 1993 called the Brady Bill. It was passed in his honor with his name on it. And it required a background check for anyone purchasing a gun and a 5-day waiting period after such a purchase. But it did not apply to all gun purchases, just certain types of dealers, and it's pretty easy to get around this law. There was another law passed in 1994 banning assault rifles. It was determined to be constitutional, so there's some evidence that certain types of guns could be prohibited. However, that law expired in 2004 and has not been renewed. And just one last reminder, obviously this is an important issue on all our minds on a frequent basis because we're in schools a lot. Even though a majority of the American people, but through public opinion polls, support strengthening our gun control laws, please don't forget the influence of the NRA. The NRA is probably the single most powerful interest group that we encountered in this class, and basically the pressure that they can bring to bear on politicians, either through electioneering or campaign contributions, means that our national legislature and most state legislatures have not been able to act on this issue for many, many years.
Hey guys, look at me. I'm exercising my Second Amendment right to bear arms. Oh yeah, look at these. Whoa. Talk about guns.
Let's get out of here.
Are unconstitutional.
Good idea.
Look at them. Whoa. Yes. Yes. Oh.